All rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Pardon me. This is a time set for oral argument. In our case, Lee versus ING Investment Management, CV150025. Each side is allocated 20 minutes for oral argument. If appellant wishes to reserve a portion of that for rebuttal, you may do so, but you're the keeper of your time, so you'll need to keep track of that with the clock at the podium. Out of respect for counsel, I would ask those in attendance to make sure your cell phones are off so that their arguments are not interrupted. We've read the briefs. We've conferenced the case. We encourage you to keep that in mind as you present your oral argument. Our proceedings are being recorded and will be posted to YouTube in due course. Accordingly, as you present your argument, please state your name and the party that you represent. Let's first start with, before we go on the clock, we have been handed a series of three sort of sheets. I'm thinking by counsel for Mr. Lee, is that correct?
Yes, sir.
All right. Is there objection? And what is the purpose of these for today's use?
They're just simply visuals to aid the court in following the argument, and everything contained in the visuals is contained in the record.
Okay. Let me hear if there's any objection to the court's consideration of those for that purpose.
We do object, Your Honor. It appears to be additional briefing, which isn't allowed by the rules, and it's not part of the record below.
Okay. Any other basis for that objection? All right. Any reason why we shouldn't? Any reason why we shouldn't? Okay. We have had an opportunity to be alerted to the issue. We provided one copy before we took the bench today. We will use those solely for purposes of demonstrative reference for today's oral argument, and that is over appellant's objection. And to the extent there's anything, of course, that varies from the record controls, and we understand that. So, all right. Anything else before we get started with argument today? All right. Let's hear then first from counsel for appellant. I should have mentioned that too. Judge Portley correctly reminded me that we do have a cross appeal, so you'll need to keep track of your time and split that as well. But each side gets 20 minutes all up. All right.
Thank you.
Counsel.
May it please the court, my name is Tracy Miller. I represent the appellant cross appellee ING Investment Management LLC, which I will refer to as IIM. With the court's permission, there are two issues on appeal here today. One is the treble damage issue, and the other is the attorney's fees issue. With the court's permission, I will address the treble damage issue first, and then the attorney's fee issue, hopefully saving approximately 5 minutes for rebuttal. There are 5 independent arguments against Mr. Lee's treble damage claim that I will discuss. The first is that this court does not have jurisdiction. You cannot appeal a consent judgment, and all interlocutory orders are merged into the consent judgment under the authority in Douglas. Number 2, even if the court can hear the appeal, the trial court was right that the severance at issue, the alleged severance, was not wages under Arizona's treble wage statute. Number 3, even if there is jurisdiction and even if the trial court was wrong, there's been no finding of liability in this case. Therefore, there was no damage to award treble damages on.
The Rule 68 judgment is not a finding of liability?
It is not. It is a finding. It is a judgment, but it is not a finding of liability on the underlying claim. It's a private settlement. And one of the main purposes of Rule 68 is to promote settlements. So it doesn't show that they're liable. I'm sorry.
Excuse me. Yeah, it certainly is a form of a settlement, but unlike an ordinary settlement, this is also a judgment of the court. It is a judgment on the merits, is it not?
It is a judgment on the action. It is unclear. It doesn't mean that the defendant has admitted liability to the underlying claim. It has the effect as any other private settlement.
Well-
It's just a judgment is entered.
But unlike a private settlement, the judgment creditor can take this down to the courthouse and record it against the debtor and have a lien. And it represents a finding of liability, does it not?
Absolutely. It is a consent judgment, but it is not an admission that the underlying claim was valid. And in fact, when the offer of judgment was made, it was clear that it wasn't just resolving the underlying severance issue. We had also tacked on, for example, prejudgment interest in that. In our calculations, our internal calculations, but that's not allocated in the judgment, as it doesn't need to be, because it is, in fact, a private settlement, although it does have the force of law and that it can be enforced as a judgment, but it is not admission that IIM was liable under the alleged severance agreement. There's been no finding of liability at any point in this case by a judge or a jury. It was simply an agreement that the parties consented to.
I'm not sure that we have to parse out all of the things that you've ably covered already in regard to your merger or Rule 68 argument. But I guess I'm puzzled that IIM, I've been saying ING, so I'm trying to change. IIM is taking the position that it's not a finding against IIM for $900,000 on something in the complaint, maybe not specified.
It's not specified. So there's nothing to treble, because the trebling has to only be for wages. And there's no evidence that the judgment is for wages. It is simply a judgment. It's an enforceable judgment, but there has been no finding that it's for wages in this case. Fourth, even if there was a judgment for wages, let's say there was a judgment for wages, treble damages are still not required, because under the treble damage statute, the plaintiff would need to show that the employer lacked good faith for paying that. There has been no such finding in this case. It's a factual issue for the trial court. Number five, even if there was that, even if there was a finding by either the judge or the jury that that the employer lacked good faith to pay the money, the trial court still has the discretion as to whether or not to award treble damages.
Do you think the trial court can preserve those issues for appeal beyond a Rule 68 judgment?
The trial court, no. Okay, so in this case, in terms of how it came about with the Rule 68 order, the judgment. So it is very clear in this case that the trial court did not try to preserve any appeal rights. And if you look at the order on the motion for clarification, it says that the order is confirmed as stated on the record. And so you need to go to the record to see what was decided there. And if you look at the record, the court states repeatedly, I am not creating any appellate rights. That's not what I meant to do. The Court of Appeals is the one that decides whether or not there's appellate rights. I didn't mean to do that. I don't have the authority to create any appellate rights. So the trial court, in fact, admitted that it didn't have those rights. Turning first to Doug.
Would it matter if the court hadn't said anything, but we had its statements earlier? Would it make any difference to either the Rule 68 settlement or our jurisdiction?
It would, if the judge had expressly reserved it, is that the question? Would that have made a difference?
Ultimately, would that have made a difference?
No, I don't think so, because I don't think that the court had the authority to reserve appellate rights. The court admitted that. He cannot create appellate rights. Now, we could have tried to fashion the settlement to do that. I don't even know if that would have been effective, but that clearly was not done here. We repeatedly said, and it was made crystal clear, that we were trying to terminate this action, terminate it completely. The idea was we wanted no further litigation. We stated that repeatedly. We stated it right before they accepted. So,
other than attorney's fees, right? Because the offer of judgment didn't resolve attorney's fees. To follow up, though, on Judge Portley's question, what if the trial court thought it could do that and could not?
I think we'd be in the same place, that the trial court does not have the authority to create appellate rights. If the trial court had done that, and because that was something that came up during one of the hearings, was the court said, okay, you can either accept the judgment and terminate everything, or it was when they were considering our motion to dismiss as moot, and the court said, well, perhaps then I will grant your motion that it's moot and make him, in essence, take the judgment, but then I'm going to say, the appellate rights are saved. And then he went back and changed his mind and said, no, I don't want to do that. I'm just going to deny it. I don't feel comfortable putting him in that box where either he has to accept and terminate all appeal rights, or I'm going to make him.
Was that the same hearing where that change occurred?
It was the first one. So there's the first hearing where for our motion to dismiss. And if you read the transcript, the judge is going back and forth and ultimately says, no, I'm just denying the motion. So, and we say, fine, we want our offer to be the normal effect, as we said over and over, which is no appellate rights, it terminates the action. Then the order came out, and the order, when it came out, said that it preserved that the court preserves the party's right of appeal. And so I wrote to Mr. Connolly and said, whoa, that's not, I don't remember the court trying to create rights. Do you? Do we need to clarify it, or can you accept my representation that that is not what we mean in this offer? In response, they just went ahead and accepted the offer and said, in reliance on the court's order, we accept the offer. We therefore filed a motion for clarification, and the court said yes, that we were right. No, I'm not trying to create any appellate rights. I can't create something. I don't have the power to do it. That's not what I want to do. And at that point, Mr. Lee's counsel moved to vacate the offer and acceptance. The court said, no, we have an offer and acceptance. We're done, and terminated the case below. Mr. Lee says now his counsel was mistaken with regard to Douglas, because in that hearing, that was one of their concerns. Under Douglas, all interlocutory orders are merged in that final judgment, and there's no appellate rights. And so now their position is, well, Douglas doesn't apply, that Douglas only applies to class certification. That is not the holding of Douglas. Douglas broadly states that it's a well-established rule that a party cannot appeal from a judgment to which it consents. And cites a string of cases, only one of which involves class certification. The cases on which Mr. Lee relies, Wersch and Preuss versus Stevens, involve a situation where there's a pending offer of judgment. The offeror is granted summary judgment, and then the offeree says, I accept the offer. That is not relevant here. In fact, those cases are not even cited by the Douglas case, which was a later court opinion. Turning to his underlying argument, even if there is jurisdiction, is this severance? Would this alleged severance be wages? Could it be wages? No, the court was right there, that wages under the statute are for amounts that the employer owes for work actually performed. Here, that's the holding of Nieto-Sanchez, and the Shade opinion does not hold otherwise. In that opinion, there was a severance, but the employee was required to stay with the employer in order to get that severance. Here, Mr. Lee admitted that he had to perform no work to get that severance. If he'd have been fired immediately after signing the agreement, he would have been entitled to the severance. That's undisputed. And even if we're wrong, even if, and this is going back to the point we started, we were discussing early in the beginning, is even if we're wrong on both of those, court has jurisdiction and it's considered wages, there does have to be an underlying judgment. Here was a voluntary settlement. I want to address, Mr. Lee states several times throughout his brief that IIM knew it owed money. It knew it owed money, and they refer to internal correspondence. The internal correspondence in this case doesn't say that. They're discussing a settlement that always presumed that Mr. Lee would sign the release, which for some reason he has always refused to do. Always was he required to sign that release. And plus, the trial court in this case denied summary judgment. So we had cross appeals on that issue, on the issue of liability. And the court found that there was a dispute The court could not decide whether or not there was even underlying liability. So there's never been a determination of liability. I believe Mr. Lee, in a footnote in his brief, says, oh, the court decided the issue of whether or not this agreement there's liability a long time ago. No, that was never decided in this case. Mr. Lee cites the case of Acevedo versus Phoenix Opportunities for the proposition that the appeal court can award treble damages without this underlying finding of liability. Acevedo, which is a 1976 case, does not hold that. He ignores all the later cases that say that it's within the trial court's discretion whether or not to award treble damages. And in fact, he ignores the Apache East case, which the court even says, in talking about the Acevedo case, that in that case there had been no dispute that the employee worked overtime and was entitled to compensation. In that case, there had been a bench trial in which the court determined that money was owed. It was just how it was paid. That was the question there. And additionally, there are later cases where it's made even clearer that the trial court needs to consider this, and there needs to be some underlying liability in order to show that there wasn't good faith. How can there be a question about whether or not there's good faith if you don't have liability? There's no point to even get to that. In terms of, so even if the trial or the judge or jury found liability, the trial court would then decide whether or not there's good faith. And then even if there's good faith, even if there's no good faith, rather, the trial court can still say no treble damages. And I'd like to refer the court to D. Amico v. Structural 1, which is 229 Arizona 262. In that case, there had actually been a jury determination that there was not good faith by the employer. Nonetheless, the Court of Appeals recognized that the trial court, even in that circumstance, could determine that there was no treble damage.
To get there, though, wouldn't we have to, your argument is that the trial court made no liability determination at all. So we're adding a theoretical hypothetical on top of another theoretical hypothetical, isn't that?
Correct. That is correct. I'd like to reserve the rest of my time. I want to handle the issue of attorney's fees, but I'd like to do that on my rebuttal.
Thank you, Ms. Miller.
Thank you.
Mr. Conley.
May it please the court. My name is Thomas A. Connolly. I'm here on behalf of Curtis Lee, who is in court today with his lovely wife. I'm also joined by my partners Leo Buse and Tom Gilson. Your Honors, in December of 2001, at a time of great merger activity, Mr. Lee accepted an employment contract from IIM, which promised that if he was ever fired without cause, he would receive a severance payment equal to his average annual salary plus the average annual bonuses that he had earned during the 3 full calendar years before his termination. 7 years later, in June of 2008, Mr. Lee became disabled. Shortly after that, after being on disability, he was terminated without cause. Mr. Lee then reminded IIM that he had this severance contract and that he calculated under that contract that he was entitled to $920,769, which consisted of $210,000 for his base salary, which is an undisputed amount, and then $710,769 for the 3-year average bonus component. IIM refused to pay that amount. Instead, what IIM did was it offered Mr. Lee $439,000, $493,333,000, if I said that right, But they conditioned that payment on Mr. Lee's execution of a release that was not required by the original agreement. The agreement itself, which is at IR 91, Exhibit 5, the release itself says that the release specifically covers but is not limited to any claim I may have for wages, and then it goes on to list a number of things, and then it says there's an exception, except for claims related to benefit plans covered by ERISA. In IIM's $493,000 offer, which is at IR 90, Exhibit 2K, the offer, as I said, was in exchange for Mr. Lee's execution of the release that was attached to the agreement, which he was always ready and willing to sign once he knew what he was going to get paid. But then there is a request that Mr. Lee execute a covenant not to sue IIM or any affiliate not directly charged with administration of the long-term disability plan in any action for damages, benefits, breach of fiduciary duty, or any other claim under ERISA. They were asking him to release them for claims that were specifically preserved to him under the terms of the severance contract. That's bad faith right there. In addition, what the letter says
Did
is...
the court find that there was bad faith? I know you're making the argument.
Well,
But did the court, as a matter of law, make that determination in some ruling in this record?
no, Your Honor. The court did not make that ruling as a matter of law, unless you look to the attorney's fees and consider the. Well, you know what? Let me stand back for 1 second.
Okay.
The trial court did make a determination in relation to the motion to compel discovery documents early on in the case, and the trial court said that ING's conduct in the case bordered on bad faith. So early on in the case, we have an indication that there's bad faith going on.
But you're not suggesting, are you, that a statement like that in addressing a motion to compel is akin to a substantive determination for treble damages, that bad faith is present?
Well, I think it sets the stage, Your Honor. It may not be a judicial finding of bad faith, because the court admittedly did say that the conduct bordered on bad faith. It didn't actually say it was bad faith. But I think it was very prophetic for the court to say that at that early stage.
Mr. Connolly, could I ask this question, please? I'm not clear on how these various arguments survive the entry of judgment and the Douglas case.
Your Honor, let me address that. First of all, I don't think Douglas is applicable here, and the trial court ruled also that Douglas was not applicable here.
Because it's a class action?
Well, I think that might be a distinction, but the greater distinction is that the offerees in Douglas never took any steps to preserve their appeal rights before they tried to appeal after they had accepted the offer of judgment. In this case, IIM was well aware that Mr. Lee placed monetary value on his appeal rights. There were negotiations leading up to the offer of judgment where Mr. Lee specifically told IIM that he placed value on his appeal rights. For instance, IIM had asked Mr. Lee to make a settlement offer, and on March 25th of 2014, Mr. Lee did exactly that, and he gave IIM two options. He said, I'm willing to accept $1.02 million with the reservation of my count 3 appeal rights. If you don't want to take that risk of the trial court being overturned, then I'll accept $1.5 million and include the appeal rights, a waiver of those appeal rights. IIM rejected that and came back with its settlement offer of just under $900,000. That was the one that they coupled with their motion to dismiss Mr. Lee's remaining claims as moot, and that which eventually morphed into this offer of judgment. So Douglas, I think the trial court was right to say Douglas doesn't apply. Not only that...
If we were to agree with you, what's the remedy? Your clients accepted a Rule 68. There's a judgment resolving this, but if we were to say we get to the substantive issues, but the case is over, then what?
Well,
What are we, if we were to agree, what would we be telling the trial court to do, or trial judges in all of these cases to do with respect to claims that one or the other party might have?
Your Honor, if I understand your question correctly, I think there are a number of things. First of all, if you wanted to give some direction to trial courts about what to do with Rule 68 offers of judgment, I think and litigants, the direction should be that if there are issues that the parties are aware of and you're intending to extinguish or resolve that issue, then make it expressly a condition of your offer of judgment. In other words, if there had been a previously adjudicated claim, as there was in this case, that was no longer a part of the case because summary judgment is an adjudication on the merits and removes the claim from the case, then it should be incumbent upon an offeror to say, I'm willing to accept judgment on the remaining claims, and also I want you to expressly waive your appeal rights on this earlier dismissed claim. I think that's not difficult to do.
Well, a rule could read that way. You're right. You've described a world that could exist. And the question is whether Rule 68 as it currently exists requires that. And you're taking various positions on whether it does or it doesn't. So your suggestion that this court could give guidance that to resolve a complete case, a Rule 68 offer of judgment has to say, we'll allow judgment to be entered for this number to resolve all claims, and we really mean all claims. I mean, this court could say that. But the question is whether Rule 68 says something different now. And to follow up on Judge Portley's question, how then would this appeal look if your client's appellate rights were truly preserved? I suppose, and I'm almost certain this isn't your argument, that this court could say, you know what, your client has no claim. And the Rule 68, whatever money exchanged hands was wrong. The money should go back, and the case is over. Isn't that the implication of your argument about how Rule 68 should apply in this case? I mean, I'm not saying you want that result. But
No, we certainly don't want that result, and I don't think our argument implies that as the result.
But if the issue still remains viable, why couldn't this court dig deep into that issue and say you lose?
Dig deep into the Rule 68.
The appellate rights that you believe are preserved. I mean, the assumption is those appellate rights, the hope is that those appellate rights would benefit your client.
Yes, sir.
But they might not.
Indeed. And if they didn't, all he risks is not getting treble damages. I think that this court could enter a judgment on, leave it status quo. But I think there are better reasons that the count 3 appeal rights don't merge into the offer of judgment, and I think there are 5 points that I can make on that. The first one is that count 3 had been dismissed at summary judgment before IIM made its Rule 68 offer, and as I said, an adjudication, summary judgment is adjudication on the merits, which just...
Was that a final judgment, though? Was that a 54B judgment, or was that an interlocutory ruling?
There was no 54B language, Your Honor. But El Paso Natural Gas and 4501 North Point are both cases that I think where the courts say that a summary judgment is an adjudication on the merits. And so the case is gone. Black's Law Dictionary tells us that as well.
Before we get to Black's, there's a difference between an adjudication on the merits, wouldn't you agree, and whether this court can exercise appellate jurisdiction over what I think the statute and the rule refers to as a final judgment. Those are two different things.
Granted, Your Honor, they are. But Rule 68 itself does not address how an offer accepted under it affects prior adjudicated claims. And we believe that if you read Wersch, what Wersch says about Rule 68 is it says the better interpretation of Rule 68 is that it does not allow a party to nullify a summary judgment. So in other words, IIM can't come along and give an offer of judgment against itself on a claim that it won at summary judgment. That would be legally and logically impossible. They can't accept an offer of judgment against themselves on a claim they won at summary judgment. And so I think Wersch is right that you've got to interpret Rule 68 as saying you can't undo what was done at summary judgment. And so if the wage claim was dismissed at summary judgment, IIM can't undo that. Second, the terms of a Rule 68 offer must be definite, unconditional, and unambiguous. IIM here crafted an order that was silent on the appeal rights, knowing Mr. Lee's position on those appeal rights. The courts tell us that silence in that instance creates an ambiguity. The trial court then is well within its rights to construe any of the ambiguities, and the case law tells us that ambiguities must be construed against the drafter.
Mr. Conlon, let me ask you, and I want to come back to the 54B concept. If following entry of summary judgment against your client on count 3, a 54B judgment had been entered and the time passed and no appeal was taken, the trial court literally would lack jurisdiction to amend that, to alter that in any way. But that's not what happened here. And so I understand your thought that summary judgment in many respects means finality, but in terms of a final judgment, it doesn't necessarily.
Granted, Your Honor, but we did file a motion for reconsideration, and the trial court again denied that motion.
And again, though, that denial did not follow or take the form of a 54B judgment where there was no timely appeal, meaning it became final. Isn't that fair?
That is fair, Your Honor. But also, the trial court listened to these arguments, listened to Ms. Miller say that IIM was not intending to leave anything open, and the court considered the totality of the circumstances, how we arrived there, and was very disturbed by the way that we got there, and the court described it as IIM trying to put Mr. Lee into a box at the last minute. Mr. Lee was ready, willing, and prepared to go to trial, which started just 10 days after their settlement offer. And there's no question that had we gone to trial and prevailed, there would have been an appeal on count 3. Those rights would have existed. And I think what the trial court was trying to do was trying to preserve that. The trial court never tried to confer any rights. There's no, and I agree with Ms. Miller that the trial court said he wasn't trying to confer any rights, but he was expressly stating that he was preserving whatever rights the parties had. And I think he's well within his right to do so. He didn't change that order at all. Early on in the April 29th hearing, he made that ruling. Then later on, the court took some time to consider it and went and I think did some research, came back out on the bench at that same hearing and said, I'm affirming my prior ruling that I'm preserving appeal rights.
But let me ask you, if as opposed to conferring versus preserving, and I appreciate that distinction, but if there were no rights to begin with, preserving the rights the parties had simply did that.
There were rights, Your Honor. IIM can't wash away Mr. Lee's rights by remaining silent. If they intended their offer to do away with the rights, knowing that Mr. Lee placed value on them, they had an obligation as the master of their offer to expressly include a waiver or a merger of those. They just sat back and said, "Oh, we're gonna rely on the normal effect of an offer of judgment." Well, you need to consider the circumstances, and if you're thinking that there's a waiver, even though the offeree is saying, I'm not waiving these things, but you remain silent, Then you then open yourself up to interpretation because you've drafted an ambiguous offer. The court interpreted it as a matter of law, which is entitled to do, and that interpretation went against IIM as the case law says it should. And so, there simply was not a merger here because IIM didn't do what it needed to do. I'm running short on my time, so I'd like to move over to the attorney fees issue. First of all, IIM has not met its burden. The trial court is entitled to great deference on its determination of who is the successful party. And in this case, the trial court determined that Mr. Lee was the successful party. And this court cannot overrule that determination unless it was clearly erroneous, and must affirm the determination if there is any reasonable basis for it. This court also must view the record in a light most favorable to upholding the trial court. The fact that Mr. Lee did not recover the full measure of his sought-after damages does not mean he was not the successful party, and IIM has the burden to prove otherwise by pointing to something in the record that shows that the trial court was clearly erroneous in its rulings, and it can't do that it abused its discretion. They can't do that. The trial court relied on the totality of the circumstances, which I believe was the correct test. And under the totality of the circumstances, we've got 5 points. Mr. Lee achieved the overall result he sought in the litigation. He received a judgment. He sought some money. He got the money. In fact, he was asking for $920,000 back in June and July of 2010. And lo and behold, he gets an offer for $900,000, 4 years and $1 million in fees later. So Mr. Lee achieved the overall result that he sought in the litigation. ING did not prevail on its primary objectives, and if I can, for a moment, just refer your honors to one of these visuals. Lee was the successful party. IIM lost its key questions at summary judgment. The first 2 questions there, IIM identified in its brief as its key questions. They lost those questions. So Mr. Lee prevailed. Now, IIM acted in bad faith throughout this litigation in 5 broad ways. It determined before suit was filed that it was liable to Mr. Lee under the contract and owed him at least $493,000. Even though it had determined it was liable to Mr. Lee under the contract, it filed 2 motions arguing that it had no liability under the contract, and it lost both of those motions. They refused to produce relevant documents until compelled to do so, and when they did so, they dumped 27,000 plus pages on Mr. Lee without doing any prior review for relevance, confidentiality, or privilege. That's what the trial court below said bordered on bad faith. They continued to make those relevance and privilege objections despite the ruling. And then only 10 days from trial, they engaged in this procedural gamesmanship to deny Mr. Lee his right to a trial and a jury verdict. I think all of that adds up to an abuse of discretion by the trial court in not awarding Mr. Lee the full measure of his damages. And I see my time has run out, and if the panel has any questions, I'm glad to take them.
Thank you, Mr. Cohn.
Thank you.
Ms. Miller, rebuttal.
Mr. Connolly stated that there was an offer, that was made prior to this litigation for $920 to resolve it. That's not accurate. That offer also required IIM to admit that he was entitled to disability benefits for a long period of time and that he was entitled to a life insurance policy of over $1 million. So several million in addition to the $920. So that's simply inaccurate. In terms of the settlement negotiations, I do want to clarify that. Prior to the litigation starting, we offered the $493,333 with internal correspondence that showed that IAM was willing to go up to $670,000. Mr. Lee did not respond to that. He instead filed a lawsuit demanding over $2.7 million. That has never changed. There has not been any other concrete offer. Now, even after summary judgment was granted against him and his claim was cut by 2/3, even after that, finally in 2013, his counsel floats a verbal offer saying, 1.5 plus reinstatement of his life insurance policy, which, again, is worth a lot, and legally you can't do that. And it was just a verbal. It was clear he didn't have authority. And then in 2014, right before trial, they float another pseudo offer. And again, this one's in writing, but it says in the offer, Mr. Lee has not approved this. And we'd have to work really hard to get him to do it. So never. We have not received any offer. So we're ready to offer up to $670 before the lawsuit's even filed. We offer $900, and that resolves it. Today, he received the $900. We're willing to pay the $900,000, and if we had gone to trial, we would have appellate rights too. We had a very strong argument on the condition precedent, and we would have those appellate rights. By making the offer of judgment, we understood that we gave that up.
But you're arguing who was the prevailing or successful party.
Correct.
But how do you overcome the simple fact that he had nothing and he filed a lawsuit and he came out with $900,000?
It's a lot. It's absolutely a lot of money. But you need to look at what he asked for. And if you're looking at the totality of the litigation, when you're asking for over 3 times that much and you're unwilling to deviate from that, he's unwilling today to deviate from that.
3 times is rather known to all of us because of the trebling statute that may or may not apply.
Right, but the point is that if you're asking for over 2.7 and you get 900,000, well, that's a lot of money to get. That doesn't make you the successful party for purposes of the fee shifting statute, which is in trying to deter litigiousness. It's trying to deter a party seeking treble damages even after the court says they're not, and sticking with that. You want to get the parties to resolve the litigation. You don't want to have them continue to take these positions to make it a windfall. And he's always done that. I mean, we have an offer of judgment for $900,000. That's a lot of money. He still wants it. That was more than he could get at trial. Still wants to get that trebled. Never has deviated from that position. And if you look in terms of the history of the case and what was done, that was what we were fighting. He says now it was a tertiary issue, the treble damages. It was a critical issue in the case. I mean, that was that was 2/3 of his case. We won that. We won another issue for $163,000 on the issue of calculation of damages, which he brought up again in connection as calling it a breach of the covenant of good faith and fair dealing. We won that again. He never won nothing. I mean, there was nothing he did to further the result other than to continue to incur fees that we had to fight against. We had no choice unless we were going to.
Could I direct you to the merger argument? I think Mr. Connolly said that the Douglas case was distinguishable because the party there, the offeree there, made arrangements or worked on preserving some appellate rights, and that didn't happen here.
Douglas doesn't say that. It's not Douglas.
If messed up offeree versus offeror.
No, I think that was correct, and I understand the point. But Douglas doesn't say that. 2, it was very clear what our offer was. It wasn't ambiguous at all. It was said.
Did your offer speak at all to the point of whether this resolves everything globally and there will be no appellate rights?
We said in this action, which under Rule 68, under the Arizona Rule 68, you don't have to say that because it says that it's the whole action. That's what Douglas says. But we even went so far as to say this action. We made it clear. And as I said, we told him that repeatedly, and we told it to him right before he accepted that offer.
And how about, I guess your answer would be the same to Mr. Connolly's argument that IIM can't take away Mr. Lee's rights by silence. I guess your answer would be, well, the rule controls.
Correct. The rule controls, and that's what we kept saying. We wanted to have the normal effect of a Rule 68 judgment, which is to terminate the litigation in whole, all appellate rights, the merger of the interlocutory orders. And this was an interlocutory order that a year and a half after it was ordered, to show it was interlocutory, a year and a half after it was entered, they moved to reconsider it.
But if the trial court interpreted the context, and it's in a better position arguably to do so than we are, if the trial court interpreted the context to allow for preservation of appellate rights beyond the offer of judgment, shouldn't that be meaningful to us now?
But the court didn't do that. The court preserved whatever rights, but the court made it clear that it had no idea what those rights were. It did not make a finding that Douglas did not apply. It said, these are all very interesting arguments. It's not for me to decide. It is.
The court ultimately said, I'm not creating,
Yep.
but maybe there is a distinction between creating and preserving.
There is a distinction between creating and preserving, and he was not trying to create. The court was just preserving the rights as they exist, and it was clear that we believed that there were no appellate rights, and they were arguing that there was. The court said, I am not going to make that decision. That decision is for the Court of Appeals, but I'm not creating it.
Thank you.
Would that essentially be maybe a difference between a Rule 68 offer of settlement and a Rule 80D resolution that's stated on the record and either does or doesn't resolve whatever the parties wanted to?
I think there would be a distinction in that there would be more flexibility in the Rule 80D, is my understanding.
Okay.
But
It seems that there's some morphing of that as opposed to at least what our case law has traditionally said about Rule 68.
I agree with that, Your Honor. I believe that's correct.
Thank you, Ms.
Thank you.
Miller. Mr. Connolly, we will allocate you 2 additional minutes on your rebuttal on your cross appeal if you wish to use them. If you wish to waive them, that's just fine as well.
No, Your Honor, I will go ahead and use those.
Very well. We'll get 2 minutes added.
And what I'd like to do, Your Honor, is...
And again, on the cross appeal alone, we'd appreciate that. Thank you.
I'm sorry?
On the cross appeal alone.
Yes, Your Honor, on the cross appeal. And we cross appealed on the wage claim. And what I'd like to do during this 2 minutes is just point, Your Honors, to another visual. The wages include severance pay visual. And point, Your Honor, to the similarities, the many similarities between this case and Shade, where the Supreme Court in Shade took issue with this court for engaging in an overly restrictive interpretation of the wage claim statute. And in Shade, the Supreme Court reversed this court and sent it and affirmed the trial court where there had been a determination that that Mr. Shade's severance was wages and that he was entitled to treble damages under the wage claim statute. And here are the similarities. And some of these weigh even more heavily for Mr. Lee. In Shade, there was an oral contract of severance. Here, we've got a written contract of severance. In Shade, Mr. Shade resigned and then agreed to stay on for another additional amount of time. Here, Mr. Lee had options to leave at this time of merger activity, but he agreed to stay when they gave him the contract. Mr. Shade worked for 3 more months. Mr. Lee worked for 7 more years. Dietrich, the employer in Shade, did not have a policy of or practice of offering severance. In contrast, here, IIM, a large conglomerate, had written policies and practices of offering severances. In Shade, he was offered 62% of what he was entitled to. Here, Mr. Lee was only offered 58% of what he was entitled to. Finally, Dietrich applied pressure to Shade to try to get him to accept less than he was entitled to. Here, IIM applied pressure to try to get more from Mr. Lee than it was entitled to. Under those facts, the Supreme Court said severance is wages, there was bad faith, treble damages are appropriate. The same result should obtain in this case, Your Honor. Thank you.
Thank you, Mr. Connolly. Counsel, we appreciate your arguments today. We appreciate your briefs. We'll take the matter under advisement. We'll issue a written ruling in due course. We'll now take a break so we can set up for our next oral argument. For those of you here for there, I apologize that we're getting a little late start, but we'll be just fine. Thank you.